friends, how are you? Myself is Dr. Jinesh Soni. In today's class, we will discuss the strategical pattern to defend the cases or charge under Section 8 of Prevention of Corruption Act. The topic is quite important because it is not easier to break the charges regarding Section 8 of Prevention of Corruption Act. So we need a proper strategy, we need a proper focus so that we could gather the scenarios and could easily attack the charges of Section 8 of Prevention of Corruption Act. Please be noted, directly criminalize the act of giving or promising an undue advantage to induce or re-award the public servant for the improper function or performance of the duty. So basically, we are having the fundamental idea about Section 8 of the PC Act. So I am going to repeat it again. Please note down in your notebook as well. So the prime key is the intention of the accused. So intention is one of the most important and basic element of Section 8 of PC Act. And apart from that, it is the criminal offense. In addition to this, it inter alia provides punishment regarding the act of giving. Please be noted, the act of giving, including the act of promising to give. The undue advantage, basically it is bribe or illegal gratification so that the public servant could be induced or the reward could be given to him for improper performance or discharge of his duty assigned to him. So I think that you are having the fundamental idea about Section 8 of PCA. Now I am coming on the legal defenses and the strategy, which are typically used in cases of Section 8 of PCA. Please be noted, number 1, the compulsive defense theory. This is one of the most important theory of defense which is provided by the Act itself. Under the proviso attached to Section 8 subclause 1, you could claim the immunity or protection if you show that there is coercion on the part of accused person. For example, you were compelled or forced to give the undue advantage. Simply we could say the practice of extortion. And within 7 days, you inter alia reported the matter to the concerned law enforcement agency, means CBI or ACB. So basically we have to note down, it is called the 7-day rule. If inter alia there is compulsion and there is no reporting by us within 7 days, we could not claim the benefit of the immunity. So basically we have to prove the two important facts. Number 1, there was a compulsion. Number 2, within 7 days from compulsion, we have reported the matter to the concerned law enforcement agency. Now I am coming on point number B. We have to show that there is no mens rea on our part. The prosecution has to prove that the money or gift is intended to be given so that the public servant could be induced or re-award could be given to him regarding the improper performance of the duty assigned to him. So basically, if we are taking the strategy or taking the defense that it is basically the personal loan, it is basically towards the repayment of debt, it is basically a social gift which having no connection to the public servant work, in that scenario the charge might fail. But such defenses must be avoided, because if we admit that we have given or promised to give certain money or certain gift, although we are having defense that it is having no connection with work of public servant, but the said defenses might cause hot water for us. So basically we have to work out on the theory of compulsion. The theory of mens rea might affect our case, our defense. So basically I request all of you to avoid that theory. But simply as per the facts and circumstances, we may inter alia put up certain circumstances by which we could show that we are having not intent to give the bribe amount or to give the undue advantage, rather than we were compelled or we were extorted to give the bribe amount. So we could inter alia put up the theory number 1 and 2 in cumulative way to have the proper defense on the record. Apart from that, we must understand that in trap cases, Honorable Supreme Court specified that mere recovery of money is not enough. So basically, a public servant never demanded, and inter alia, you could show that you are inter alia indulged with strong or ulterior motive on the part of public servant. In that scenario, we could be succeeded, but mere averment are not sufficient because Section 8 of PCA cover both the cases, the case where you give and the case where you promise to give. So basically, the theory of compulsion is the best defense among all the defenses which are inter alia provided to contest the charge of Section 8 of the PCA. Sometimes the lawyer may say to you that you may challenge the sanction, but please be noted there is no requirement of any sanction as far as the offences of Section 8 of PCA is concerned. Apart from that, we have to see the officer rank who is going to investigate your case. If there is violation of Section 17 of PCA and Section 26 of B and SS, we could take the benefit. And apart from that, the phenolphthalein test is having no value concerning cases of Section 8 of PCA because you are the bribe giver. The public servant will make the complaint that you are going to compel him to discharge the duty in the improper way. So you will be trapped. The money will be given by you. In that scenario, if you are going to think that you will disprove the phenolphthalein test, you are wrong in your approach. Phenolphthalein test is having no connection with cases as per Section 8 of PCA. So we could emphasize on Section 17 of the PCA and Section 26 of BNSS. This appears to be the good defense strategy among all the strategy which I inter alia specified to you. Apart from that, if there is inconsistency in the statement of witnesses, the witnesses are not independent, and apart from that, there is contradiction, there is lack of corroboration, the complainant turned hostile, we could be succeeded. So simply we could say that Section 8 of PCA cover the cases where the concerned person gives or promise to give the undue advantage to induce or to re-award the public servant so that he could discharge his duty in the improper way. So if discharge is not in the improper way, apart from that, the public servant concerning whom the charges are leveled is not assigned with any duties. In addition to this, we are not having any intent. In addition to this, we could show that we were compelled to give the bribe, and within 7 days, we specified the fact to the concerned law enforcement agency. In that scenario, we could be succeeded to break the charge of Section 8 of PCA. So, in the conclusive way, we could really submit that to defend a charge of Section 8 of PCA, we have to emphasize on 5 important points. Number 1, you are having no intent to bribe the public servant. Number 2, you were compelled within 7 days, you have reported. Number 4, the consent duty is not pending. In addition to this, there is contradiction in the statement of witnesses, and apart from that, the material witness are not supporting the case of prosecution. In that scenario, we could be on the best side to succeed concerning charges of Section 8 of the PCA. See you in the next video. Till then, Jai Hind, Jai Bharat.